Welcome to this cornerstone presentation on Housing Judicial Review Tactics 2020. I'm Kelvin Rutledge. We're particularly sorry we can't be with you in person this year. It's been a very, very difficult year for many professional and lay clients alike. And so we're particularly delighted that so many of you are able to join us today. It's very much appreciated. Thank you. Now, over the course of the next 45 to 50 minutes, you'll be seeing and hearing from 4 members of Chambers who will take you through the judicial review process with particular emphasis on housing issues. Chambers has always undertaken a good deal of JR work for both local and central government, but there's no doubt that in the housing field, this is a growth area. In fact, around 25 to 30% of Chambers' housing work is JR related. Solicitors' firms are becoming more specialised in this area, and the message that we intend to send out with this presentation to you today is that local authorities can be good JR litigators too, and many are. Now, all 4 presenters today have housing-related JR experience. Time is of the essence, so if you have a question, I'm very happy to take questions or points. You can do so during the course of the presentations, but it might be easier if you store them up for the dedicated Q&A at the end of this 1 hour. So let's make a start, and Alex, if we can have the first slide on areas of potential challenge by way of judicial review. Thank you. Now, the main areas that we've seen challenges in the administrative court are undoubtedly in relation to all forms of housing allocation or homelessness policy making. Anything under Part 6 is invariably challengeable by way of JR, but increasingly decisions or policies, more particularly made under Part 7, out of borough placement policies, charging policies and the like, they're all likely targets for judicial review proceedings. Local authorities acquire, hold, dispose of a good deal of land, much of it for housing related purposes, and that's a developing area for JR challenge, as is housing related finance, the way that local authorities are increasingly using their creative wider powers of competency to find other ways of delivering housing. That has financial implications. All those policies are potential targets for judicial review. Increasingly, we're seeing challenges to local authorities either internally in relation to the interrelationship between housing services and other linked services such as children's services, adult social care, education, and the like. And also sometimes, necessarily as a practitioner, I think, between one local authority and another in relation to the range of territorial issues that will arise. And all sorts of housing related policy is challengeable or potentially challengeable by way of judicial review. Rent setting, ASB policies I've mentioned, and of course licensing schemes in relation to housing and contracting out. So there's a very wide range of potential targets, and we in Chambers have seen challenges in pretty much all these areas. Next slide, please, Alex. What do you need? If you want to set yourself up as a good local authority JR litigator, you need a toolkit. It's a very, very simple toolkit, not much more than a hammer and a screwdriver. The hammer is the Senior Courts Act 1981, previously the Supreme Court Act 1981, which had to be changed for reasons you'll guess. Section 31 underpins the remedies that the court will grant, mandatory order, quashing order, and declaratory relief. It's always worth just having that to hand to see what the remedies are. That, of course, is fleshed out with CPR 54, and in particular, practice directions A and D. Those encapsulate all the law, in effect, legislation and rules that you need. But really, The essential document that you need is the third on my list, and it's free. It's the Administrative Court Judicial Review Guide. It's amazing how many people don't use this or don't even know of its existence. This is a wonderful publication. It's normally produced or updated annually. It's written largely by administrative court judges, but more importantly, it's issued to all administrative court judges. And they love you citing it because it's easy for them, very accessible, up to date, authoritative, and free. So that get that and make sure that that's on your desk. And finally, the Administrative Court Cost Guidance, April 2016, which is still the latest guidance, which you don't have to go out and get specially, because helpfully that's reproduced in Annex 5. But obviously you'll need to know that guide. It's all based on a case that Catherine was involved in a few years ago. She'll talk about, no doubt. But that's it, that's your toolkit. That's all you need to be a good, and a bit of nerve as well, obviously, to be a good JR litigator. Next slide, please, Alex. So the three critical stages, that I call them, these are three stages in a JR case where a local authority defendant can potentially influence the final outcome. These are three critical stages. The first is the pre-action protocol stage. There's no doubt, in my view, that a complete, firm, robust protocol response will put the local authority in the best possible position to defend. In fact, it might even put the claimant, or more particularly the legal aid agency, off issuing in the first place. Now, we all know it's not always easy to get instructions early on in a case. Local authorities have been said not always putting their best foot forward on the first occasion. But if you can, and indeed some of my client local authorities have their own internal protocol for exchange of information from client departments to make sure that a robust protocol response can be put in, but it also sets you up so well for defending the case later on. We'll see that the summary grounds should really refer back to the protocol. And if it's not such a blatant advert, it's a good stage, the protocol response, in the right case, to bring in counsel, because you may just save their brief fee at the end of the day. So get the team on board early, work out, is this a case we're going to win? Is this a case we want to fight? What other tactics? So that's a critical stage. The second stage, Alex will talk to you about more particularly, and that's the permission interim relief stage. There's no doubt that's another point at which the case can be influenced. Nowadays, the claimant, it's sort of red, amber or green for a claimant. Green means permission, red refuse, but amber, conditional permission or a rolled up hearing or something like that. But it's another point, an area where the local authority can seize the initiative, particularly on interim relief and setting up a status quo, which can then influence the outcome. And finally, of course, the response stage. Even then, it's not too late to review. We've seen a number of authorities, starting with Brewster in the Supreme Court, more recently and more relevantly for housing, Hulu and Hillingdon in the Court of Appeal, which says that local authorities can revisit, for example, their Public Sector Equality Act duties at a later stage. You could even do it then. So those are the three critical stages. Next slide, please, Alex. The need for procedural rigor. It used to be the case that judicial review, unlike ordinary commercial litigation, was quite lax in its approach, and that judges didn't rigorously enforce the rules as they might in other proceedings between private parties in relation to the points that can be argued and such like. Probably because it has a public law element to it, so anything's allowed. That's changing. And we have this very powerful statement from a senior Court of Appeal judge, Lord Justice Singh, about the need for procedural rigor. It says, fairness and the ordinary management of litigation require that there must be an appropriate degree of formality and predictability in the conduct of public law litigation, as in any other form of civil litigation. Courts should be prepared to take robust decisions and not permit grounds to be advanced if they've not been properly pleaded. It mentions the habit of grounds evolving during the course of proceedings, particularly in the final skeleton arc. How often do we see that? This is a really helpful case to have at your fingertips if you find that the other side, perhaps they realise that their pleaded grounds are not as good as they might be and seek to evolve them. Next slide, please, Alex. Time limits, and at this point I remind myself that we only have 12 minutes each. We started a little late to allow some colleagues to join, so I'm going to deal with this fairly quickly. We're all familiar with it. Unlike the Limitation Act, you don't get a guarantee of a certain time to issue a claim form. It has to be issued promptly, and in any event within 3 months. There's a limited power to extend that. A lot of claimants forget that. So first thing you need to look at as a defendant, are they in time? And the Secretary of State for Trade and Industry case, Lord Justice Laws, is quite an old case now, but it's still very important because it reminds us, fairly obvious point, but it emphasises that the decision is normally the decision first time of asking, because you will find that many claimants will say, oh, it's an ongoing duty, continuing breach or something like that. Well, actually, that's a fairly rare occurrence. So you need to understand what is the decision, actual decision that's been challenged, are they in time? Next slide, please. Alternative remedies. Again, this is all stuff. We've given you these slides because these are things that hopefully you can readily access when you get that protocol response in or you get the claim form. Because there's no doubt that if there's an alternative remedy, and in local government work, there very often is a local, an alternative remedy, as recent case I've given you there, which sort of discusses this, is a really powerful, potentially knockout point on the judicial review. Next slide. And linked to that, ADR, the Cowell case tells us that ADR, is, alternative dispute resolution, is just as important in public law proceedings as it is in any other type of litigation. Arguably, it's more important because of the public expenditure and the public interest. It's not every judicial review case in public interest that goes for a full hearing. And so there may be other ways. I mentioned ordinary residence dispute. That's a classic area in which ADR may be a much better way of resolving it. Thank you. Next slide. And I've given you, you can look at it for yourself, but I'm sure those of you who don't already use it will go away, I hope go away from this presentation and download the Administrative Court Guide 2020. But I've given you a citation from that. Again, that's a really useful quote to use if you've got claimants or claimant solicitors who are intent on issuing. Alex, next. Thank you. Pre-action protocol compliance, I've given you the reference for the protocol. I'm sure you're familiar with it. The rules are fairly clear. The protocol doesn't hold up the time limits, but it does have important implications for costs and case management. The point I've already made, it's a very, very good opportunity to understand what your case is, understand the strengths and weaknesses of your case, and to put that forward at that early point. Next slide, please. There have been a couple of cases on claimant's duty of candour. This is a very powerful statement in the Afghanistan Secretary of State for Home Department case from the Lord Chief Justice about the claimant's duty of candour, which kicks in right from the start. So look to see what evidence or representations are being made by the claimant. As the Lord Chief said, gaps in knowledge should not be filled by wishful thinking. this is an ongoing duty. It goes right up to and beyond the final hearing, but it's particularly important early on. Just check, are the facts that are being asserted correct? Thank you. Next slide. And I've given you a 2018 case here, which again, very helpfully, if you just want a quick reference for this, go to this case, cite it, and the other side will be taken aback. Duty to assist the court with full and accurate explanations of all facts. Witness statements must not be deliberately or unintentionally obscure areas of central relevance. No spin. Breach of duty can occur by admission. No disclosure of a material document fact. So it's all pulling together, isn't it? That judicial review is becoming far more commercial and business-like in its approach, what it involves, particularly when it involves local authorities, I would suggest. That there's a duty of procedural rigour, there's a duty of candour. And these are all areas that local authority lawyers should be looking at and, where appropriate, exploiting. And that's me. So I'm now going to, so we've now dealt with the pre-issue stages, and we're now assumed that despite the robustness of our protocol response, the other side have issued, and they'll be applying to the court for interim relief. So I hand over to Alex.
Thank you, Calvin. So in terms of interim relief then, it works in much the same way in judicial review as it does in normal civil proceedings, in the sense that Part 25 governs the procedure, and in the sense that the applicant has, as Kelvin mentioned, those very strict duties of candour and disclosure, particularly where an interim application is made without notice. The claimant's duty to disclose all the material facts that are or should be known to it on a reasonable search of the information are very important indeed. And typically, the court will discharge an interim injunction, for instance, if it turns out that material non-disclosure by the claimant has happened. One point that arises from a recent case in relation to interim relief is from the Knowlson case earlier this year. If interim relief is refused on the papers by the High Court, what avenues are open to the applicant to challenge that decision? Knowlson decided that there is jurisdiction under Part 3.3 of the CPR for the applicant to ask the High Court to revisit the decision. And crucially, that means that the applicant doesn't have to go to the Court of Appeal on that particular point. Now, there's an exception if the parties are both happy for the issue to be dealt with on the papers. It becomes very difficult then to say that it should be challenged on that basis. But if it's decided on the papers, an interim relief is refused, then that avenue exists under Part 3, and Knowlson makes that clear. Sorry, I can't do the slide and the speaking at the same time. So now you have the slide and on to separate issues of interim relief. The applicant needs to think very carefully whether it's appropriate to go without notice. It isn't usually appropriate to do so. And this lengthy passage from B Borough Council and S makes 2 points essentially. The first is that it may not be necessary to go without notice, and applicants need to think very carefully about that. But also, the applicant who goes without notice must think very carefully about what to ask the court in terms of the return date. The starting point is that it's the applicant's job to justify to the court why interim relief should be granted. It isn't the respondent's duty to justify to the court why it should not. And so the starting point is that wherever interim relief is granted without notice, the respondent needs to be given the opportunity to come to court to make representations on whether the interim relief should be discharged as soon as possible. And the upshot is that parties are to be discouraged from boilerplating by copying and pasting draft orders from previous cases and asking the court for the same thing each time. Applicants need to think very carefully about what the circumstances require and bear in mind the respondent's rights to be heard. And so the upshot is that respondents need to be given that opportunity to come back as soon as possible. And this point's put very forcefully by Mr. Justice Munby in Casey. allowing the respondent to make representations means essentially within a matter of days at most, not weeks, and certainly not months. So that return hearing should be held in that kind of time frame. And now Kelvin's mentioned the summary grounds stage. When an application has been received, if the parties have been complying with their pre-action duties, and Kelvin mentioned the importance of doing that, particularly if you're a defendant, the case should be pretty clear to the defendant by the time that application is received. So at the summary grounds stage, there's no need really for anything particularly lengthy. The parties will usually know each other's arguments in a fair amount of detail if they've followed the pre-action protocol procedure. And so at this stage, something fairly short is all that's required. Defendants are, however, asked to draw attention to any knockout points. Kelvin mentioned limitation, for instance. If there are any obvious limitation points to take, if you're a defendant, then that's the time to do that. It might also be appropriate to draw the court's attention to practical or financial consequences of the claim, which may justify a request for the claim to be expedited, for instance. Any issues like that should be raised at that stage. But generally, there's no need for anything particularly lengthy. What is the court looking to when it considers these issues, in particular when it's considering whether to grant leave? Well, one thing that the court has to bear in mind is the materiality of the alleged breach. It's always been the case that judicial review remedies are discretionary, in the sense that even if the claimant demonstrates unlawfulness on the defendant's part, that doesn't necessarily lead to a remedy. That idea has been put much more robustly, has been set into statute. It's now in the Senior Courts Act 1981, and it has been since 2015. The court has to consider at the leave stage, or doesn't have to consider, but it's entitled to consider at the leave stage, whether the outcome for the applicant would have been substantially different if the conduct complained of had not occurred. And in particular, if it does reach that decision, then it must refuse leave. Now that's an important point, that the intention clearly is to discourage, on Parliament's part, is to discourage applications which, while they have some legal merit, are effectively pointless in practice. And so again, if you're a defendant and you think that there's a materiality issue here, it might be alleged, for instance, that the defendant has failed to take account of a relevant consideration when making the decision. If, as a defendant, you think that would have made no difference to the outcome, then again, that's a point to raise at the summary grounds stage. Now, if a decision might be unlawful, what can a public authority do about that? It may try to do one of two things. It may try, first of all, to ratify that decision. Generally, the scope for doing that is incredibly limited indeed. Ratification is a complex area of law, it's a very uncertain area of law, and the scope for ratifying an unlawful decision is very limited. What the defendant may try to do in judicial review proceedings is provide post hoc justification for a decision. It may later proffer reasons and evidence in support of a decision that weren't necessarily within its contemplation when it made that decision. Can it do that? And can the court take those things into account? Well, the answer is yes, it can. The court can take those things into account. But the further the public authority gets from the circumstances that were before it when it made the decision, generally the more difficult it will be to adduce those additional reasons to put forward that post hoc justification. And that point essentially is being made in Brewster. There are some circumstances where the courts will take post hoc justification seriously, but it will subject post hoc justification to a fair amount of scrutiny. So in other words, the circumstances what was within the contemplation of the decision maker at the time are relevant. Those circumstances are relevant when the court looks at the legality of the decision. We come then on to a more advanced stage in the procedure. After summary grounds of opposition have been put in, what then happens? Well, within 35 days of permission being granted, the defendant has to file and serve, firstly, detailed grounds for contesting the claim, and also any written evidence that it wishes to put in. Now, it's at this stage that judicial review begins to look very different indeed from ordinary civil procedure, in the sense that in judicial review, there is no formal disclosure process, as Kelvin mentioned earlier. The traditional reason for this is that usually by the time it gets to judicial review, the parties are arguing essentially about the lawfulness of a decision, and the facts are, sometimes, but not often, in heavy dispute. Now, that has implications for the defendant. Because there's no formal disclosure stage, it's very important that the defendant puts before the court all of the relevant facts and the reasoning behind the decision in order that the court can assess the legality of it. That duty, as Kelvin mentioned, of candour, is a very high duty to make full and frank disclosure to the court. And again, we come back to the issue as to whether the public authority can adduce supplementary or additional evidence to support its decision, to support or justify the decision. And the answer is yes, it can. But of course, if it contradicts the reasons that the defendant gave for making the decision at the time, then that's not going to really help the defendant. And so, as Kelvin mentioned, those things are definitely relevant. In terms of preparing for the final hearing, after the detailed grounds procedure, or after the detailed grounds stage, we're looking to the final hearing, and the parties have to do three things. The first is to put in skeleton arguments. The claimant has to do this not less than 21 days before the hearing. The defendant then gets to put their skeleton argument in not less than 14 days before the hearing. So the defendant has some time to reflect, obviously, on what the claimant is arguing before putting in their skeleton. The parties must also put in a bundle. This is the claimant's responsibility, but the parties are expected to cooperate and agree a joint bundle that contains all the documents to which they intend to refer at the hearing. In terms of authorities, the parties are, let's say, discouraged from taking a belt and braces approach. When they're putting authorities in, the authorities that they rely on shouldn't normally exceed 10. They really must limit themselves to necessary authorities that go to the disposal of the claim or which establish the particular principle of law that's being contended for. In some cases, it may be entirely possible to dispose of the issue without citing any authorities at all. The principles may not be in dispute, the principles may be perfectly well known, and if that's the case, there's no need for the parties to burden the court by asking the court to consider in any more detail than it has to the relevant law. What is the scope for third parties to take part in judicial review proceedings? I can see Catherine is waving. Can you all see that slide? Interested parties and interveners, is that right?
Just looking at the time, love.
Oh, I see. Okay, I'll make this quick in that case. Sorry. Interested parties and interveners. You may apply to be an intervener. Parties may apply, but the court has to consider very carefully whether that's appropriate. Obviously, if you're an interested party, you're directly affected by the claim. You will be served with the claim form and you can take part if you wish. With interveners, they have to justify the intervention. The court has to consider whether it will assist. The court also has to balance the contributions of the intervener against any delay or expense that the intervener might, or the intervention might involve. And generally, interveners have to bear their own costs. And sometimes, in limited circumstances, they may be ordered to pay the costs of other parties if, for instance, they've behaved unreasonably or their intervention doesn't assist the court. As Kelvin mentioned, settlement is to be encouraged if the parties can reach it. A claimant can discontinue a claim if the claimant wishes to do that. There are cost implications under Part 38 of doing so. If the parties settle, then they'll need to proffer a consent order, put a consent order before the court. If they wish to quash, or if they agree to quash the decision, then they should include in that consent order a schedule giving the reasons for doing that, so that the court can have some oversight of that and be satisfied that quashing is justified, and the consent order should also make provision for costs. Now, after settlement, the parties must try to agree their costs. If they can't, then the cost guidance mentioned in the Administrative Court Judicial Review Guide kicks in. These cost principles in the Judicial Review Guide reflect the Croydon case, and that requires the parties to consider 3 different scenarios. One is where the claimant has wholly won and induced a settlement that is exactly what the claimant was asking for. The second is if the claimant has succeeded in part but may have lost on other points. That will be relevant to the costs issue. And thirdly, if the parties have compromised in a way that doesn't actually reflect what the claimant was asking for, then that's something they will have to bear in mind when they agree their costs as well. Now, if they can't reach agreement on costs, and this is my final slide, then the administrative court cost guidance becomes relevant. First of all, the defendant puts in submissions 28 days from the court's order, the order that disposes of the claim, essentially. The defendant files submissions. If the defendant doesn't do that, then the usual order is that the defendant will pay the claimant's cost of the claim. If the defendant does do that, then the claimant and any other party has 14 days to respond to those submissions. If no one does that, then the usual order will be whatever the defendant was asking for. And if counter submissions are put in, then there's a further 7 days for the defendant to file and serve a reply. So that is the slide saying the last word. Those are my last words, and I will hand over now. Thank you.
Thank you very much, Alex. Well, the first 2 speakers have proved that you can never rely on counsel's time estimate. So anyway, I hope I'm looking at the number of participants. We hope we don't lose any of you. You'll stay with us. With the very interesting presentations to follow. So next up is Wayne.
Wayne, are you there, please?
Well, we have a timekeeper for this afternoon, or this morning as it still is, and hopefully will remain this morning by the time I've finished as well, inside my 12 minutes. So knowing that we do have a timekeeper, I'm a serial recidivist, as some of you will know when it comes to timekeeping. And I think Zoom probably makes this worse, but I have deliberately tried to address this defect. I'll leave it to others to decide at the end of my 12 minutes or however much longer it may be to decide whether or not that's been successful. What I propose to talk about in rising to Kelvin's challenge in counsel keeping their time estimates are 5 key cases that have arisen relatively recently, dealing with recent approaches in JR decision making and respecting some of the facts and principles that have been discussed earlier and relating to tactics in judicial review. First of all, always remembering that the merits of the decision-making process must be for the local authority concerned. And secondly, that as long as all the relevant matters have been taken into account, then the appropriate threshold for challenge is perversity or proportionality in some cases. And then thirdly, considering the vexed issue of reasons and the importance which public lawyers often stress to public authorities of trying to ensure that the reasoning in their decisions is sufficient to grapple with the issues that are actually being raised. But there is an important point about whether or not reasons need to go further to deal with potentially obvious issues which haven't necessarily been raised on the papers. And there's some very helpful clear guidance in one of the more recent cases showing that in fact if neither of those 2 principles apply, then the reasoning doesn't need to cover any other particular points unless there's a statutory obligation, a specific statutory obligation to do that. So the first of the 5 cases that I want to talk about, and these are in roughly reverse chronological order, is the case of Flores. Now that was a judicial review challenge to Southwark's allocation scheme, and it arose in circumstances where someone was assessed under the scheme placed into band 3, one of the lower bands. And the first thing to note about this case is that there is an appeal outstanding up to the Court of Appeal. So it's an interesting case to keep an eye on to see if matters develop when it reaches the Court of Appeal. But the case revolved around the fact that the claimant in that case entered a tenancy of a 1-bedroom flat together with his partner and his then 2 young children, but knowing that they would all be occupying this 1-bedroom flat. And then after quite a lot of time passed, what had happened is that although the flat was always overcrowded under Southwark's internal policies, it became statutorily overcrowded under the provisions that we're familiar with within the statutory scheme. And so the question that arose, because there was provision in Southwark's policy for dealing with how to treat individuals who found themselves in housing difficulties through a deliberate act, was whether in these kinds of circumstances Southwark could decide that this was a deliberate act. And so if we move on to the next slide, what we can see is that 2 key points arose in that case. The first related to investigation and the second related to causation. And again, in relation to investigation, public lawyers are familiar with the idea that there's an obligation on a public authority, whenever there's a duty to inquire, to put itself, whether that's expressed in the statute or implied from the circumstances, to acquire sufficient information about the situation so that it can reach a proper decision on all of the issues that fall for consideration. And so in relation to this case, on the investigation side, what was found was that a deliberate act under Southwark's policy, and this is capable, as it seems to me, of much broader application than that, but it didn't mean a deliberate act which was undertaken by someone deliberately trying to, as it were, frustrate the housing allocation scheme or further their position in the housing scheme. It was enough that it was something that was done voluntarily. So because of that, it didn't matter whether or not the claimant knew that under the terms of the statute or the terms of Southwark's scheme, after an extended period of time, as a result of the presence of the children in the household, they would naturally have been advanced to band 1 if this provision hadn't been applied by Southwark. So there was a sufficient investigation on that point because it was legally irrelevant to the consideration of deliberate act, whether or not something was in the terms of the statute or the scheme. And on the issue of causation, which is another vexed one, that is important that we recall that public authorities, as part of their fact-finding duty and part of their ability to assess the merits for themselves with limited intervention from the court, is that it's for the authority to decide what the effective cause of something happening is. And so in this case, it was said that the authority's approach, which at first blush might seem difficult in a period where a number of years have passed since the family had first moved into this accommodation, their approach was described as perfectly sensible to find, as they did, that it was inevitable that this problem would occur as the children grew older. And that situation was contrasted with 2 obvious potential categories of case, and that's the one where additional children come into the family over time. Whether that happens through normal additions to the family or by other means such as adoption and so on. So in either of those cases, issues of causation can arise, but where it was simply the existing household growing older, then the finding of the local authority was unassailable. So can we have the next slide, please? The second case I want to talk about is a case that has again been quite widely reported. It's in the PTSRs on application of M versus Newham, and it's a slightly unusual case in that it involves the use of mandatory orders. So public lawyers will be familiar with the fact that where decisions are struck down, typically what happens is that it's sent back to the local authority for reconsideration on a proper basis, sometimes as directed by the court. But on very rare occasions, there can be mandatory orders where the local authority is actually ordered to take a specific course of action. That's unusual in the first instance. It's even more unusual when it's dealing with something like the scarce resource of limited temporary accommodation. But that's what happened in this case, but for very specific reasons. It was one of the rare kinds of cases where the local housing authority admitted that it was in breach of the duty under section 1932 to provide suitable housing accommodation, and in fact that had been the position for a period of about 2 years. And so on those unusual facts, if we move across to the next slide, what we can see is that the court, in what is actually a very helpful and very detailed distillation of a number of principles, set out 2 key principles which tend to arrive quite often in these kinds of challenges. First, that it is open to a local housing authority, subject to usual challenges related to irrationality or other conventional public law complaints, to conclude that accommodation will be suitable by reference to or for a period of time. So, for example, bearing in mind the scarcity of housing stock, there will very often be circumstances where accommodation, which is far from ideal, is having to be provided in the short term, sometimes medium term, which, as we know nowadays, can translate into extended periods of months, sometimes years. There is, in law, no particular difficulty with that, although there will always come a point where it simply becomes irrational for someone on their given circumstances to continue to remain in accommodation that is that far from ideal. But where this is being dealt with by the authority as a way of discharging their duties, then what becomes clear from this case is that the decision letters should be explicit in that respect, and they should provide reasons for it as well. And insofar as it's sensible in the individual case for those reasons to also be explicit within some parameters about the likely length of time that someone is going to spend in temporary accommodation, then that is also something which ought to be attempted in the letters, again giving reasons which can be related to the general difficulties in securing housing, which is often in these cases of a quite specialised nature, which doesn't occur very often on the local authority's books or even on those of other authorities that it might cooperate with. So the second point is in cases where the housing authority has concluded, those rare cases where it has concluded that the accommodation is no longer suitable, what the statute doesn't provide is any further period of reasonable time for the authority to cast around and try and find alternative accommodation. Whilst no court will normally make a mandatory order requiring an authority to try and do the impossible or nearly impossible, in those circumstances, there is no significant further period of time that is allowed to the authority under the statute at least. So carrying on to the next slide. One of the reasons that Newham is a useful case, as it were, to have in your back pocket or at least in your file is because it contains over 40 paragraphs, quite a detailed distillation of all the cases dealing with suitability, temporary accommodation. The 5 that I've mentioned there, I won't read them or go through them in any detail, but those in particular that have gone up to the higher courts, Cadona and the Birmingham cases, will be well known to a number of people who are watching. But it's just a very useful synthesis found in one place and in some level of detail of all of those authorities. So worth having it for that reason. And so next slide. Also, another reason why M is a useful case is that in a previous case in 2001 called Khan, the judge in that case had set out, really by way of observation rather than necessarily setting down as a criteria-based exercise, 5 things that might be taken into account in trying to decide whether or not mandatory relief should be granted in these kinds of cases. And what the judge did in the Newham case is really picked up those 5 features, used them again. And so going forward, there is likely to be a trend where this is the test that's being applied. And certainly if you're trying to defend a case of this kind, then no criticism could be made if these were the kinds of considerations that your authority looked at with a view to deciding whether or not it was a case where you could, even if you were in breach or on the cusp of being in breach, whether or not you could nevertheless sensibly sustain an argument in relation to trying to resist relief being granted by the court in relation to that breach. And the list is the nature of the temporary accommodation. So there will be cases where it appears that the accommodation that's been provided is really quite a long way below the qualitative assessment of what really ought to be provided in order to constitute suitable accommodation. There will be other cases where the difference is much more marginal, and in those marginal cases, of course, it may be more acceptable for someone to stay in sub-suitable property for a more extended period of time. Second point is the length of breach. Third, the efforts made to secure accommodation, really important to evidence that. That is a tactical issue where authorities can strengthen their cases very significantly by showing not just the passive, but also the active steps that they have in place to try and ensure that they're doing their best without scouring every estate agent's window, to show that they have processes in place that allow them to pick up potentially suitable sources of accommodation. And the prospect of accommodation in the near future, if someone's likely to be accommodated in the near future, then there may be no need for a mandatory order. And then last of all, the catch-up criterion of any other relevant factors. So next slide, please, Alex. Warden Hillingdon, another significant case in the Court of Appeal with wide-ranging discussion of issues, and it was judicial review to an allocation scheme relating to the application of 10-year local residence rules, which residence rules obviously have become increasingly popular in areas where there is very high demand for accommodation locally. And the questions that arose I've put on the slide, whether that was discriminatory against two particular classes of potential applicant, if so, whether that was justified, and thirdly, whether there was a breach of the well-known PSED. And so moving on, we see what the court did about those things in this case. First of all, they held that in relation to those two groups, on the usual approach of looking at the groups, how groups in society are effective rather than specific individual comparators, which is the important difference between analysis of direct discrimination and indirect discrimination. The court held that there was indirect discrimination there. And they said that when you're considering those questions, it's right that you don't focus on the one individual provision that's in front of you. The local authority are entitled to pray and aid, and the court can look at the scheme as a whole to see if there are adequate safety valves or other mechanisms within it that may serve not to adequately offset any difficulties that have arisen as a result of what on the face of it on one provision works in a discriminatory fashion. So it's always worth looking at the whole balance of the schemes that are in question. In that particular case, the authority had chosen to focus on whether or not the scheme as a whole corrected the issues. And so there wasn't for that reason, there wasn't a detailed evidential discussion in relation to justification, but the court did give examples later on in the judgment that are worth looking at if you've got a case where you think you're going to have to acknowledge either as a primary case or as potentially as a secondary case if you were to lose on the scheme as a whole, to look at ways that you might deploy evidence to show that overall the scheme is capable of being justified in any indirect discriminatory impacts it may have. But it's important the evidence is there because as the court rehearsed here, there is an onus on the policymaker to justify any discrimination that is found to have arisen. But the critical thing perhaps that comes out of that case, which is a much wider application, and it's been held as an approach in other areas of public law as well, is that the justification in relation to discrimination, indirect discrimination, can rely on evidence that is generated after the event. So Alex was giving an indication of all of the areas earlier where it's important that your evidence is either generated at the right time or is at least consistent and simply elucidates what you've previously done. But in relation to justification, the position is slightly different. Obviously, a measure of consistency is still extremely helpful, and the court does look with closer scrutiny at reasons that are given after the event. But there is no bar in law in providing quite detailed justification for indirect discrimination after the event. That's worth bearing in mind. And I've given the paragraph references. So next slide, please. Adesoto and Lewisham, an important case dealing with the extent of the court's jurisdiction under Part 7, challenges on a point of law under Section 204. And it's often said and almost assumed that that is identical to a claim for judicial review. And the court in this case had to consider whether or not it was a claim for judicial review, a claim made under Section 204, for the purposes of applying the Equality Act provisions contained in Section 113. And the court decided that it wasn't. And so if we go on to the next slide, because I'm conscious I am going to run out of time otherwise, this is the most important point in the case, that a Section 204 claim is not a claim in judicial review for these purposes. That's because where Section 113 confines claims that can be made under that part of the EA to claims for judicial review, that is a term of art. And that's a broad point that applies across the board, not just to housing cases, but for example, to the case of Hamnet as well, where there was an experimental traffic regulation order challenge which failed for similar reasons. And so Section 113 of the Equality Act doesn't apply to 204 appeals. The court simply has no jurisdiction to determine those kinds of claims. So if there is an allegation of a breach based on the early provisions of the EA in sections 5 or 9, that can't be entertained by way of Section 204. Next slide, please. Just to confirm, also in Adesoto, it's been established before, but there was an argument against it in this case which failed. There is no jurisdiction in the court under a Section 204 appeal to decide primary facts for itself. So the law as stated in the case of Bubb and Wandsworth remains good law, and if you need a recent authority backing that principle up, then you'll find it very clearly expressed in Adesoto. Moving on, please, Alex. So the last case that I referred to, and I've done it more shortly because it's a case where the facts really are quite important. And so if one wants to deploy this authority, it is important to have a look at the report in detail and see the facts. But it was another set of 2 JR challenges to allocation schemes. And within that case, there's a very recent example of decision letters which were sufficiently robust to demonstrate in a way that satisfied the court how the vexed issue of out-of-area placements could be dealt with lawfully. And in this case, in the principal appeal, it was a movement from Brent to Birmingham, and all of the reasoning that underlay the decision is set out within the authority. And there's also within that case, the idea, and it's dealt with in a separate subheading with about 8 to 10 paragraphs supporting it, about the point I was raising earlier about sufficiency of reasons and whether or not and in what circumstances it can be necessary to have reasons that deal with an issue that isn't expressly raised by the representations that are made in the Housing Act cases within the course for a review. And so that's, again, a very helpful and authoritative restatement of the guidance about sufficiency of reasons. And I wasn't keeping too close an eye on the time, but I hope I haven't run too far over. And that's my contribution for today. And it's very good to see you all virtually, at least.
Thank you very much indeed, Warden, for that. My calculation, you compressed your presentation into, I think, just 12 minutes and 900 seconds. Right, well, for those of you, I'm conscious of looking at the numbers of participants. I'm confident we will overrun because we've saved the best to the last, as usual. So I can now hand over to Catherine, who's going to give us a rundown on recent cases on housing law.
Yes. Thank you. And what I'm going to do is be able to pick up some of the threads that my colleagues have given you already and talk about how judicial review is really a living, vibrant area of the law and developing all the time. And in particular, in cases that include intersectional areas of the law, we're talking about housing-related judicial review here today. But of course, houses don't come on their own. People live in houses. People need not just a roof over their heads, they need help to live there. they need care, they have children that come and go, they have all sorts of issues that don't fit into nice little segments. And so I wanted to mention something that I haven't got a slide on, which follows on what Kelvin said earlier about the formalities of judicial review. And he gave you that quote from Talpada and Secretary of State for the Home Department. And in a recent case of mine, which was before Mr. Michael Fordham QC, who is a very recent High Court judge, but as you will know, is someone who's written the book on judicial review and has got very firm ideas about how judicial review should develop in future. He said, yes, that's all very well and good, but in certain cases, and housing and care cases are absolutely really good examples of this, you may need to have rolling judicial review, because the dynamic reality, he said, can mean that there's a moving target and a moving picture. So although classic JR is a challenge to a decision at a moment in time, not looking at things that have happened since, very often by the time you get to court, things have moved on, you've done further assessments, the child has turned 18, somebody's moved out, somebody's moved in, they've got leave to remain, all sorts of things happen. And he says, you have to be flexible, you have to allow for judicial review where it's fair to the parties to do so. And sometimes the courts will look at post-decision material, and that means, of course, that local authorities have got the opportunity to maybe pick up some of the dropped stitches in earlier decisions. And that leads me to this slide, which is about what Alex was telling you about earlier, about section 31(2)A, plus what Wayne was telling you about, which is that section 204 appeals are not technically judicial review. Because section 31(2)A of the Senior Courts Act, formerly known, as Kelvin told you, as the Supreme Court Act, renamed in, this section was added in 2015. This is one of the government's first attempts to control, I think, judicial review and stop, how is it the Prime Minister puts it, stops the courts being hamstrung by lefty human rights lawyers and do-gooders. Yeah, good luck with that one, Mr. Johnson. Because section 31(2)A says that where the court thinks that the outcome will be highly likely the same, if the local authorities dropped the stitch, as I was just saying there, had they done everything that they should have done, taken into consideration all the facts and not taken into consideration irrelevant facts, they would probably still have come to the same conclusion. Then the High Court must refuse to grant relief. That is to say, may say, look, the local authority got it wrong, but same thing anyway, so not going to quash your decision, off you go, carry on as you were. The question in the recent case of McMahon and Watford, which was the 204 appeal that went to the Court of Appeals just before lockdown, was whether that's applied in 204 appeals. Now, in my view, it doesn't really matter whether it does or not, because the court has always said it's not going to do that. If the decision is immaterial, I was taught by a very senior practitioner to ask the question, if so, so what? Then we're not going to quash in any event. The court does not beat the air in vain is another phrase that's often being used. But as it turned out in McMahon and Watford, Watford had taken the right decision for the right reasons, and so it didn't arise in that question in that particular case. So that's a question for another day. Does this part of judicial review apply in 204 appeals? So if I can have the next slide now, please, Alex. It says that section 204 appeals are akin to judicial review. And as I say, it's just common sense to say the same thing. Okay, next slide again, thank you. This is a recent challenge in relation to temporary accommodation in the acute context of the pandemic. This was kind of a moving target, kind of rolling review of what the suitability of temporary accommodation. This was a man who was vulnerable to coronavirus. He first demanded self-contained accommodation. The local authority gave him self-contained accommodation. He then demanded a bed. The local authority provided. The housing officer of the local authority gave him one of his own mattresses to make sure he had somewhere to sleep. Went absolutely beyond the call of duty. He then demanded a fridge and a cook and someone to clean the fridge for him, so the targets kept moving further and further away. In the end, Mr. Justice Martin Spencer said, basically, the local authority is not required by the housing law provisions to provide furnished accommodation. And what's really interesting about this case is that when refusing interim relief, one of the things that the judge took into consideration was the strains on local authorities due to the pandemic. You all know better than we do what strains those are. People are working from home, people are working with limited resources under increased strains. And the judge said that that was something to be balanced in the decision-making process when deciding whether or not to grant interim relief. This was a local authority who had done everything possible to assist this man, and he was then asking for more and more things which he wasn't going to get as an interim relief option. Of course, interim relief very often is the beginning, middle and end of a case. Sometimes it doesn't go any further than that, save as to arguments as to costs. And I think this is one of those cases. It hasn't come back to the court. But one of the things that Escott raises as an issue is the question of vulnerability to coronavirus and the extent to which that is something that local authorities have to cope with in these unusual times. So if I can have the next slide, please. Idolo and Bromley, this is a judgment of Rowena Collins-Rice sitting as the Deputy High Court Judge. And this is one of those intersectional cases where the Care Act duties and the Housing Act duties come in to play together with Article 8, respect the home, added in as an extra support to the arguments. And this was a case where the claimant lived in an 8th floor flat. Suddenly, for some reason I couldn't quite get my head around, he suddenly ended up paralysed and wheelchair bound. And it was clear that he needed ground floor accommodation. Bromley did its Care Act assessment, absolutely perfectly, acknowledged that he needed ground floor accommodation. Bromley then did absolutely everything right as a Care Act authority. With care duties, they went round and helped him. They provided him with all the care that he needed to live on a day-to-day basis. But there was a long delay in processing his application for a move. And on the next slide, please. He argued that it was the care side of Bromley that should have been dealing with this housing application, not the housing department. But Section 23 of the Care Act draws the lines between the two. So the council has no duty, and indeed it has no power to do things under the Care Act, things that it must do under the Housing Act. So there's a very clear demarcation there. So what she said was, on the one hand, local authorities face the irresistible force of demand to meet properly assessed needs for adult social care, including needs for decent, adapted or adaptable housing. On the other hand, they face the immovable object of limited housing resources and the housing duties they owe to others in the community. So yeah, Bromley had Mr. Idolo's care needs very firmly in view. But when you're making decisions about care needs in relation to housing, or housing in relation to your care needs, then you have to have regard to the fact that there are other people who may also need the house. So what's the solution to that? The solution the law appears to provide is very simply rehousing needs, even if identified through the Care Act route, cannot shortcut the detailed system of balanced priorities within Housing Act schemes, but must find their proper place within those schemes. In other words, your Care Act needs do not circumvent the need to go through the housing scheme, the allocations or homelessness applications that you need to go through, so that there's the fair allocation of housing resources as opposed to care resources. And of course, those two play different roles, although complementary roles, in meeting people's needs. Can I have the next slide, please? It's working together is always the key, talking to each other. Duties under the Care Act include identifying your housing needs, but meeting the housing needs is the job of the housing department. He had been given reasonable preference under the allocation scheme, so Housing Act duties were fulfilled. And Article 8 didn't add anything to this. There was no culpable breach. Article 8 only gives you a remedy if there's something the local authority should have done but didn't do. And although there was a delay, they were meeting his care needs, they had given him reasonable preference. Reasonable preference under an allocation scheme is not a guarantee of housing. By the time it got to court, they had found him a different property to live in. So all that was left was a claim for damages. And the judge was rather critical of the parties for not having sorted this out themselves, taking up scarce court resources when they should really have been basically mediating or sorting this out without troubling the courts. Of course, again, costs may well have been a sticking point. It doesn't say so on the face of it, but that I suspect was an underlying issue. So if I may have the next slide, please. She referred you to guidance in Onufrieva, absolute classic case from way back when. And this is guidance that has been perhaps forgotten in the course of the times. It says that the claimant should explain why they're pursuing a claim for damages rather than pursuing the internal complaints procedure. If you've got an alternative remedy, don't come to court. Article 8 damages are fairly rarely awarded. Under the European Convention on Human Rights, the court will not give damages if a declaration of breach will suffice. And again, this is a case where the court has indicated that they sympathise with the local authorities about the strains that they're on. Local authorities have hard choices to make. Sometimes they are simply choices about the least unfair distribution of relatively disadvantaged. Sometimes there are few practical or satisfactory choices at all. She had sympathy with Mr. Odolo, she had sympathy with the London Borough of Bromley. Balancing it out, Bromley had done all that they needed to do in this case. Moving on now to a case, again, in front of the extremely tough tribunal, Mr. Fordham. I've already mentioned him. This was a case I did in front of him before he got the call, and it was actually the day before he was appearing in the Supreme Court on the prorogation case. And I was sitting there watching him going, why on earth are you sitting doing a case rather than sitting at home swatting up what you're going to be saying to the Supreme Court tomorrow, as any normal human being would? But he was brilliant. He really got his head around this, because this is one of those cases, again, where you've got the intersection. You've got the Care Act, you've got the Housing Act, you've also got immigration in that one as well, because this was a guy who had no recourse to public funds. He had, he said he was stateless, so he didn't have anywhere to go. He couldn't leave the country. And he had previously been accommodated by the Secretary of State in what we call mass accommodation. That's the wrong term, because mass doesn't exist anymore, but he was technically, I think, in breach of his bail. And that's probably why he approached Southwark. Again, this is one of those things that sort of under the radar was probably behind it. He had bipolar disorder, he had depression, and he did need medication on an ongoing basis, medical needs, as opposed to housing needs. But he didn't have anywhere to live because he had been sofa-surfing with friends. They turned him out. Southwark assessed him as not having eligible care needs. He challenged the factual assessment and was refused permission on that. This goes back to what Kelvin said earlier about getting your facts right first and getting a good pre-action protocol response. Southwark had sent a cracking response letter that showed why their workings were right as to whether or not he had eligible care needs. And as you probably know, you need to have particular needs in relation to being able to feed yourself, dress yourself, all those sorts of things. You need to have 2 of them before there's a Care Act duty. So he challenged that. He didn't get permission to that. What he did get permission on, next slide please, was the way you approach the human rights issues. Because he had no recourse to public funds, he was excluded from Care Act assistance unless there was a human rights issue. So he said he needed accommodation. That engages Article 8, the right to a home. No, it's not a right to the home, guys. It's the right to respect for your home. There is no Article 8 right to a home. But he said Southwark had to look at him and say, does he need accommodation in order to avoid a breach of Article 8 rights? That's the wrong way around to look at it. The starting point is the Care Act assessment, because those are the duties that you're looking at. You can only provide accommodation under the Care Act if it's a need for care and support, and so you need to be accommodated in order to have those needs met. So going back to IDOLO, housing is for the housing team, Care Act is for the Care Act team. They have to cooperate with each other, but the Care Act assessment is not a way to shortcut, to get around the limitations of housing. And in this case, he wasn't eligible for Housing Act assistance. He didn't have eligible care needs. That was the simple fact of it. So he couldn't have accommodation in order to meet those care needs. And so, although he said Southwark should have looked at him and gone, you haven't got anywhere to live. That's an Article 8 issue. We'll provide you with somewhere to live. That was the wrong way around, and his challenge on that failed. If I could have the next slide, please. They could only meet eligible care needs if and to the extent necessary to do so to avoid breaches of his human rights. That's because of his immigration status. And Fordham tried to lay down a test looking at the previous case law on what breach of human rights says. And it is quite a high standard. It can be asked to the relevant looked after need, the Care Act need, whether it appears on a fair and objective assessment of all relevant facts and circumstances that the claimant faces an imminent prospect. What's imminent is something that's been more recently considered by the Supreme Court in a case following N, which was the one I can never remember the name of serious suffering caused or materially aggravated by the denial of meeting those needs. Whether that denial is of the most basic necessities of life, it really has to be something that amounts particularly to serious suffering, really bad. Not just, oh, I'm going to be on the streets, that's really bad, it's terrible, I feel awful. It's got to be serious suffering to the point of almost amounting to torture. Many factors may affect that judgment, including age, gender, mental and physical health, condition, facilities or sources of support available to the applicant. Where else could he go? The weather and time of year even, and the period for which the applicant has already suffered or is likely to continue to suffer privation. So you could put up with something for a short period of time that you don't put up with for a long period of time. Also at the moment, coronavirus is going to be a factor in that kind of consideration. Is the person going to be in the critically vulnerable categories, so that if they get COVID, they're likely to be very extremely ill or perhaps die as a result of it. So on the next slide, please. One of the things that this case clarified was that Section 1 of the Localism Act 2011 is not a route to circumvent the statutory frameworks of housing and care. There's been previous cases where people have tried that. This, I think, puts a nail in that one. Section 1 of the Localism Act basically says that local authorities can do anything that people can do, but Localism Act doesn't provide authorities with the power to do anything they want to do. They are circumscribed by the other statutory frameworks within they operate. So we operate within the Care Act framework, the Housing Act framework, Immigration Act framework. Section 1 doesn't drive a coach and horses through that. Interestingly, though, Fordham was rather creative with Section 19 of the Care Act and suggested that that might give a local authority power to accommodate someone, even if they don't have eligible care needs, if that is the only way to avoid serious suffering. But again, it has to be serious, high-level suffering. On to the next slide, if you will. And one of the questions that's already been asked in the question and answer sessions, which is at the bottom of your screen now, so feel free to add any more on, is what the panel think are the current key areas of challenge to private registered provider decisions. What type of decisions are flavour of the month for public law challenges by claimant solicitors against housing associations, if any? Obviously, housing associations may not be susceptible to JR at all, but the Section 1 of the Localism Act makes me think that that might be one area of challenge, and that everyone in the coronavirus challenges, as you will recall when lockdown started, local authorities were asked to accommodate all rough sleepers. Roughly 15,000 people have been accommodated as a result of that. They've been placed sometimes with private registered providers, possibly in private rented, possibly in social housing. Under what provision have they been accommodated? Is it part of the homelessness scheme? And if so, does the local authority owe further homelessness duties as a result of taking them in? Is it under some kind of allocation? It will all depend very much on the paperwork you've got, what was told the provider, what was told the person in question at the time, and what previous dealings you've had with them. But I think there's going to be lots and lots of new challenges, judicial review challenges, which are going to be intersectional challenges like this. Homelessness, judicial review, Care Act, all kinds of issues may come into this, possibly immigration as well, because not every one of those 15,000 people who've been accommodated have actually got right to reside, right to rent, all of those sorts of things. So I know at least one is going up to the High Court. Justin Bates from Landmark Chambers has talked about that one. And I suspect there are going to be many more. I nearly always tell local authorities when I'm doing a lecture, keep good records. So I hope that you've all taken that from my previous records and you've got good records so we can come to court with lovely records as to how you were assessing that. Right, we've got some more questions coming through. Kelvin, do you want to take over from there?
Thanks very much for that, Catherine. I must say I'm fascinated by this whole idea of rolling judicial review. I wonder if that involves a rolling brief fee for counsel.
In my case, it involved rolling under the desk with my head over, with my ears over my hands over my ears. I'm trying to say, but
well, I mean, obviously we've gone well over time, but I'm very impressed to see that the vast majority of our participants is either still with us or they've fallen asleep. We do have some very interesting questions. Catherine's just dealt with the first one that was from Lachlan McLean about the current issues for private registered providers. Whilst my colleagues peruse the other questions, perhaps I can just deal with the second one in time, which comes from Chris Daniels. Fascinating question on which I'm sure Alex will want to express a view. And it's, is there any scope to bring judicial review proceedings against the government for the suspension of possession proceedings and elongating notice periods? Can we sue the government for doing what they did in relation to possession proceedings? Well, yeah, we certainly have, a local authority would have a sufficient interest to do that. I suppose one would have to look at it in terms of a procedural challenge and a substantive challenge. Procedurally, I assume, my colleagues will correct me if I'm wrong, but I assume there would have been an impact assessment. There would have to be an impact assessment in relation, for example, to victims of ASB, such like. So where there's an impact assessment, there's always possibility of a procedural challenge, but substantively, then one would struggle to find a cause of action. You might say Article 1 First Protocol, because it interferes with the local authority's property rights. That raises a very difficult question I haven't had opportunity to look at for a few years. Alex will update me. But the difficulty of the local authority being a victim under the convention to enable the that action to proceed. There may well be EU free movement issues as well, but then you'll be told that you're in fact suing yourself because of the horizontal vertical effect of European law. So I'd be interested in what my colleagues, if they got any particular views on it, but I think it'd be a fascinating case to try. But at the moment, I think it would be a struggle. It might well be worth the publicity though.
Yeah, just to add to that, Kelvin, on the human rights point, I agree. I think the authority would be Aston Cantlow and Wallbank, 2004, I think, House of Lords.
Yeah.
If you're not a victim under Article 34 of the Convention, then you won't have convention rights. And basically, as a core governmental organisation, you won't be a victim. So I think any challenge that was brought would have to be brought on traditional public law grounds rather than the European Convention.
Yeah.
I could see there being issues there.
Yeah, great idea. Good idea. The next question we've had from Kumo Matthews, which is an interim application, late in the day application question. For out-of-hours applications late in the day, how do local authorities get a better picture of what is being put before the court? Often seems that such applications are deliberately made at last minute. Well, Alex will give you chapter and verse, but there is an obligation on the claimants to make a note and furnish that note to the defendant or defendants so that they can see whether, apart from anything else, the duty of candour was adhered to. So there is that obligation. Alex, can you give any more detail than that?
Not a great deal more, other than that it seems to me that any litigant that's trying to deliberately make a late application to put the other side to disadvantage, that issue needs raising as soon as possible by the respondent. That is not in the spirit of a cards on the table approach where the parties are trying to cooperate.
Thank you. Next, Sarah Rumbold asks us whether Chambers will be responding to the government consultation on judicial review. Chambers will be, and we will be inviting any observations or points that our clients would like to put to us. We're happy to discuss them at any time, but we think it's important. So the answer to that is yes. We then have a question from Mary Almeida. We've accommodated a number of rough sleepers under Section 1 of the Localism Act in accommodation in which they've had exclusive occupation. The accommodation is leased on a long lease. Are those occupants protected by the Protection from Eviction Act? Can we only get them out 28 days notice and issuing in the court? Catherine, do you have a view on that?
My view is it would be safer to do so. They could be you could say that if they were accommodated under your homelessness duties, you wouldn't need to do that because of the Cien and Lewisham case. But given that you've specifically said Section 1 of the Localism Act, it seems to me that you're likely to need to give them a 28-day notice. But I would say use that 28-day period to work with them, to help them to move on somewhere else, so that you don't have them back on your doorstep under another guise, and use it as a preventative measure so that they don't come back and say, look, you were accommodating me under homelessness, I've now gone to a solicitor and he's told me that. If you've given them a helping hand to find alternative accommodation, then they're not going to be on your doorstep, either metaphorically or indeed literally when it comes to it. And so this is an opportunity, I think, for local authorities to just bring down the number of rough sleepers, generally speaking, knowing that, of course, there is very likely going to be a wave of subsequent homelessness applications arising out of the coronavirus pandemic, and the people have lost their jobs and now in rent arrears and losing their accommodation right, left and centre.
Yeah, I'm assuming that the initiative was born out of the central government guidance on to the local authorities on rough sleepers, and it certainly would be within the powers. But I mean, Catherine's point is absolutely right. You are at risk if you deal with it under Section 1, not least because they may be, you may have reason to believe that they're homeless and therefore should be dealt with in Part 7 route. But also you can't then necessarily rely on the Lewisham decision in relation to security of tenure. Chris Daniel asks us, I was thinking of a sample of a single property landlord relied on their rent and suffered hardship by not being able to bring the normal possession proceedings available at the time they issued a tenancy agreement contract. Could I call you after the webinar to discuss, please? Well, the answer to that is yes, by all means, Daniel. If you need to just check with Sam, though, because I have a couple of conferences afterwards. But I think this is a follow-on from the earlier question that you asked. Very happy to discuss that.
First question from Fabian Peter was, we made a decision saying person not entitled to be part of the right to buy application. The decision is more than 3 months old and was not challenged. JR threat against the decision, but am I correct in saying that it's more than 3 months old, they cannot JR the decision? Generally speaking, yes, but I said to Fabian, what happens very often is that you've got this original decision, you get the pre-action protocol correspondence, and they say, oh, I know I'm out of time to challenge the actual decision, but you've made a subsequent decision upholding the earlier decision, and I'm going to JR that one decision. So be careful when you deal with correspondence that you're not making a fresh decision. We have taken into consideration all your representations, and we have decided again that you are not entitled to exercise the right to buy. That one's going to be harder to do in relation to a right to buy application. But so generally speaking, once 3 months goes, you can't bring a JR claim, but there's sneaky ways around it. And those sneaky ways do include issuing on late on a Friday evening when you've gone home, although we don't go home now, we're all home anyway, late on a Friday evening, as Mary was saying, and they're all, you know, missing part of the picture. And so a judge gives you a bit of relief on a Friday evening, and then you end up fighting the case despite the fact that it's out of time. But one of the things that you need to do in pre-action correspondence is make sure you're not opening the door to a sneaky new challenge, pretending it's not the original decision that you're challenging, it's a later decision. People get away with that far too often, in my view.
Thanks, Catherine. Well, I think that's the end of the questions that we've been asked, but if you want to send in more, by all means, do so. We've overrun terribly, but I'm sorry about that. But I hope that you would have found this afternoon's presentation helpful. At this point in the proceedings, we would normally leave the pensions room and go out to the foyer and enjoy a nice lunch and meet up with colleagues and friends, people that some of us have known for years, and year upon year come along and support Chambers. But because we can't see you doesn't mean we're not thinking about you. Thank you very much indeed. And we look forward to seeing you all, working with you in the future. And let's hope we can meet up and have that lunch and that coffee and those nice Graysian chocolate biscuits next year. Thank you very much indeed for joining us. Goodbye.